Imagine setting a concrete rule, like you are building a wall,
Right.
and you declare in no uncertain terms that this wall is high and impregnable. You insist that you cannot and you will not tolerate the slightest breach.
Not even a crack.
Exactly. Not even a tiny crack. And then in the very next breath, before the cement is even dry, you build a permanent door right through the middle of it.
Yeah, you just prop it open.
You unlock it, prop it open, and literally wave people on through. How does the highest court in the land write the most famous, absolute separationist sentence in American history, in a case where the separationists actually lost?
I mean, it is the defining paradox of American constitutional law. The wall and the door were poured in the exact same batch of concrete.
Wow.
And that ambiguity, that internal contradiction, it basically became the engine for every single church and state culture war that followed.
Well, welcome to the Deep Dive, everyone. We're unpacking a massive stack of Supreme Court cases and founding documents today. We want to find out exactly when the First Amendment mutated from a fence around Washington, D.C. into, well, basically a straitjacket for your local school board.
Yeah, it's quite the journey.
It really is. We're looking at cases like Cantwell, Everson, Cochran, and Pierce, alongside Thomas Jefferson's private letters and James Madison's political pamphlets. Because whether you follow today's debates over school vouchers or religious charter schools or public funding for religious institutions, the blueprint for those arguments—
The exact language they use today.
Right, the exact language both sides use today was forged in a single, highly paradoxical 1947 decision called Everson.
Yeah, to understand the headlines today, you really do have to understand those architectural blueprints drawn up in 1947. But to grasp how earth-shattering the Everson decision was, we have to look at the legal landscape that existed for the first century and a half of the American Republic.
Right, because the First Amendment we think of today, the one that applies to the mayor, the police officer, the public school principal.
It's a relatively modern invention.
It really is. The First Amendment opens with the words, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." And for a very long time, the most important word in that sentence was Congress.
Exactly. Congress shall make no law meant exactly and exclusively the federal Congress. It was a restraint on national power. I mean, the founders were incredibly wary of the new central government they were creating, right?
Oh, absolutely.
And the Bill of Rights was designed as a shield against it. But it was not a shield against state governments. And the Supreme Court explicitly confirmed this in a landmark 1833 case called Barron v. Baltimore.
Okay, let's dig into Barron for a second, because it perfectly illustrates how different the early Constitution was.
Yeah.
So John Barron owned a highly profitable deep-water wharf in the Baltimore harbor.
Right, very successful business.
But as the city of Baltimore rapidly developed and they started paving their streets, all the runoff, like massive amounts of sand and silt, was diverted directly into the harbor right around Barron's Wharf.
Yeah, the water became so shallow that commercial vessels could no longer dock there. I mean, his business was completely ruined by the city's infrastructure projects.
Just totally destroyed.
So Barron sued the mayor and the city council of Baltimore. His argument rested on the Fifth Amendment of the U.S. Constitution, which, states that private property cannot be taken for public use without just compensation.
Right.
He argued that the city destroyed the value of his property for the public good of street development. So the Constitution says they have to pay him.
I mean, it seems like an airtight legal argument. The government takes your property, they cut you a check. But Chief Justice John Marshall, writing for the Supreme Court, he just shut him down completely, didn't he?
Completely shut him down. Marshall's logic was purely structural. He looked at the Constitution and noted that when the framers wanted to restrict the states, they did so explicitly.
Like where?
Like in Article 1, Section 10, which says, "No state shall coin money or enter into treaties." But the Bill of Rights contained absolutely no explicit language applying it to the states. So Marshall ruled that the Fifth Amendment, and by extension the entire Bill of Rights, was intended solely as a limitation on the power of the national government.
So it's helpful to think of the early Bill of Rights almost like a strict corporate HR policy that only applied to the CEO in Washington.
That's a great way to look at it.
Right. While all the branch managers across the 50 states could basically run their offices however they wanted. But why were people okay with such a massive double standard for so long? If Maryland wanted to seize your property, the federal Constitution offered you zero protection.
Zero. You had to look to the Maryland state constitution for help. And if we apply that structural reality to the religion clauses of the First Amendment, the implications are staggering.
Oh, yeah.
Because the First Amendment only built a fence around Washington, D.C., states were entirely free to manage religion however they saw fit. I mean, they could even have their own official, taxpayer-funded, established state churches.
It is so easy to forget today, but several states did exactly that. Massachusetts, for instance, they didn't fully disestablish their state church, which was the Congregationalist Church, until 1833.
The exact same year Barron v. Baltimore was decided.
Right, so think about what that meant for you as an average citizen back then. You could be a devout Baptist or a Quaker or a Catholic living in Boston in the 1820s, and your local property taxes were legally collected by the state government and handed directly to the local Congregationalist minister to pay his salary.
Yeah, your fundamental rights depended entirely on which side of an arbitrary geographic line you stood on.
It's wild.
It is. If you lived in Virginia, thanks to the intense lobbying of James Madison and Thomas Jefferson, you enjoyed robust religious freedom and a strict separation of church and state. That was codified in the Virginia Statute for Religious Freedom. But if you crossed the border and rode your horse up to Connecticut or New Hampshire, you were suddenly in a jurisdiction that actively funded a specific Protestant denomination with public money.
And the founders intentionally built that system, didn't they?
They absolutely did. They prevented a national church specifically to protect the state's rights to manage their own local religious affairs. Early Americans identified much more closely with their states than with the national government.
Right, they were Virginians or Pennsylvanians first.
Exactly. They trusted their local communities, governed by their own state constitutions, far more than a distant federal apparatus. The idea of the Supreme Court in Washington reaching down into a Massachusetts town to dictate how they funded their local parish, I mean, that would have been viewed as a tyrannical overreach.
So for 150 years, the constitutional architecture holds. The states are sovereign laboratories. But obviously that architecture doesn't exist anymore. Today, a public school in Texas cannot mandate a Christian prayer, and a town council in New York cannot ban a Muslim mosque. The First Amendment does apply to the states now. So how did the Supreme Court manage to flip the entire constitutional structure on its head?
Well, the mechanism that radically altered this relationship is a legal doctrine called incorporation, and the engine that powered that doctrine was the 14th Amendment.
Ratified in 1868.
Yes, in the immediate bloody aftermath of the Civil War.
Right, because the Civil War proved, in the most horrific way possible, that leaving fundamental human rights entirely up to the whims of state governments was just a recipe for tyranny.
Exactly. The post-war Congress, dealing with southern states passing black codes to strip newly freed slaves of their basic rights, they realized the federal government needed the power to intervene locally.
Okay, so the 14th Amendment fundamentally rewrites the social contract.
It does. And the key to our story lies in a very specific phrase within it, known as the Due Process Clause. It states, "Nor shall any state deprive any person of life, liberty, or property without due process of law." Notice the crucial addition of the word state.
Right, it explicitly targets state governments.
Yeah.
But here's the textual hurdle for me. I hear the word state, and I hear the words life, liberty, or property. But I do not hear the words freedom of speech or freedom of religion.
No, you don't.
So how does the Supreme Court use this one sentence about due process to apply the entire Bill of Rights to the states?
I mean, wait, so liberty is just this giant, empty constitutional suitcase, and the Supreme Court just slowly started unpacking the Bill of Rights and stuffing it in there piece by piece.
That is the multi-million-dollar legal question.
It seems like a massive linguistic leap. How do they justify that?
Well, due process inherently sounds procedural, right? It implies that before the state locks you up or takes your house, they have to give you a fair trial, a chance to defend yourself. But the Supreme Court eventually developed a concept known as substantive due process. Substantive due process. Meaning the protection isn't just about the process of how the government acts, but the substance of what the government is trying to take away.
Exactly. The court argued that the word liberty in the 14th Amendment is not just a procedural placeholder, it is a substantive suitcase. They determined that certain rights are so fundamental, so deeply rooted in the traditions and conscience of the American people, that they are implicit in the very concept of ordered liberty.
Wow.
Yeah, so no amount of fair process can justify a state taking those fundamental liberties away.
But the court didn't just unpack the entire Bill of Rights and dump it into that suitcase all at once in 1868, right?
Yeah.
It took decades.
It was a painstaking piece-by-piece process called selective incorporation. The court would wait for a specific case to come before them, and then they would decide if that specific right was fundamental enough to fit inside the liberty suitcase.
And we see the tracks being laid for this in the 1920s and 30s. Like in a 1925 case called Gitlow v. New York, where a man named Benjamin Gitlow was arrested for distributing a left-wing socialist manifesto.
Right.
The Supreme Court actually upheld his conviction. But almost as an aside, they declared that freedom of speech and of the press are among the fundamental personal rights and liberties protected by the 14th Amendment from impairment by the states.
That was the earthquake. They casually announced that the First Amendment's free speech clause now applied to state governments. And they did it again for freedom of the press in a 1931 case called Neer v. Minnesota, striking down a state law that allowed the government to preemptively censor a scandalous newspaper.
I mean, consider the immense transfer of power this represents. The federal courts suddenly possess the authority to look over the shoulder of every governor, every mayor, and every local police chief in the country and say, you are violating the citizens' fundamental liberty.
It made the federal judiciary the final arbiter of local disputes. But while speech and press were incorporated in the 20s and 30s, the religion clauses of the First Amendment were still waiting on the outside of that suitcase. The states were technically still free to restrict religious exercise or establish religions.
Until 1940, when a theoretical legal framework collided with the messy, on-the-ground reality of minority religions on the streets of New Haven, Connecticut. Let's talk about Cantwell.
Yes. The case is Cantwell v. Connecticut, handed down on May 20th, 1940. And it centers on a family. Newton Cantwell and his two sons, Jesse and Russell, they were Jehovah's Witnesses.
And Jehovah's Witnesses in the 1930s and 40s were intensely active, highly visible, and deeply controversial.
Very controversial.
They refused to salute the flag, which obviously caused massive friction during the build-up to World War II, and they were very aggressive in their door-to-door evangelism.
Yeah, so on April 26, 1938, the Cantwells were walking down Cashew Street in New Haven. Now, this was a predominantly heavily Roman Catholic neighborhood. The Cantwells were carrying a portable phonograph record player and a satchel of books and pamphlets. Their modus operandi was to knock on a door or approach someone on the street and ask for permission to play a record.
And the record they were playing wasn't just a polite, introduction to their faith.
No, not at all.
One of the records was an audio presentation of a book called Enemies, which contained a blistering, highly inflammatory attack on organized religion in general and the Roman Catholic Church in particular.
Unsurprisingly, playing anti-Catholic propaganda to devout Catholics on the sidewalks of New Haven caused a severe disturbance. Two Catholic men who listened to the record, John Lestis and John Cafferty, were incensed. They told the Cantwells to take their phonograph and get off the street before they were physically thrown off.
I mean, you can imagine the tension.
Absolutely. The Cantwells packed up and moved on, but the police were called and the Cantwells were arrested.
Now, let me play devil's advocate for the town here. If I'm the mayor of New Haven or the local police chief, I'm looking at the situation not as a theological debate, but as a public safety hazard.
Right, a potential riot.
Exactly.
Yeah.
I have two groups of citizens inches away from a literal street brawl. I have a duty to keep the peace.
So from the town's perspective, isn't a permit system just basic city management? They're trying to prevent street fights, not ban a religion. Why does the court view a basic permit as an unconstitutional censorship tool?
Well, let's look at exactly what they were charged with, because Connecticut defended its actions exactly as you just said. But the Cantwells weren't just charged with a generic breach of the peace. They were convicted under a specific Connecticut state statute.
Okay.
This law dictated that no person could solicit money, services, or subscriptions for any alleged religious, charitable, or philanthropic cause without first obtaining a certificate of approval from the Secretary of the Public Welfare Council.
Ah, so they were arrested because they didn't have the proper state-issued religious solicitation permit.
Precisely. The Cantwells appealed their conviction all the way to the Supreme Court, arguing that this permit requirement violated their First Amendment right to the free exercise of religion. But the state of Connecticut's defense is obvious, based on everything we've discussed so far. Connecticut's lawyers can walk into the Supreme Court and say, read the First Amendment. It says, Congress shall make no law. We are not Congress. We are the sovereign state of Connecticut. We have the police power to regulate our own sidewalks, and the First Amendment does not apply to us.
And for 150 years, that defense would have been impenetrable. But in Cantwell, a unanimous Supreme Court, 9-0, speaking through Justice Owen Roberts, officially folded the free exercise clause into the 14th Amendment suitcase.
Wow. 9-DO.
Yeah. Justice Roberts wrote the fateful words, "The 14th Amendment has rendered the legislatures of the states as incompetent as Congress to enact such laws."
It is a stunning, definitive moment. The federal government just reached into a local New Haven neighborhood dispute and completely rewrote the rules of engagement. But how does the court justify striking down the permit law specifically? Because again, a permit system sounds like basic neutral city management. You need a permit for a parade, right? Why not a permit for door-to-door solicitation?
The Supreme Court struck it down because of who held the power to issue the permit and the criteria they used. The Connecticut law required the Secretary of the Public Welfare Council to determine whether the cause was a bona fide object of charity or philanthropy or a valid religion.
Oh, I see. So the state official gets to decide what counts as a real religion.
Exactly. Justice Roberts pointed out that if the secretary decided your beliefs weren't a valid religion, he could deny the certificate. That gives a local bureaucrat the power of prior restraint. It grants the state censorial power to arbitrarily evaluate the legitimacy of a citizen's faith before they are allowed to speak. That is a power the Constitution outright forbids.
But the court realizes they have to leave local governments some tools to manage public safety, right? They can't just say religious groups have total anarchy to do whatever they want on public streets.
They absolutely realize that. And to balance those competing interests, Justice Roberts articulated a vital distinction that became the bedrock of modern First Amendment law. It's the dichotomy between the freedom to believe and the freedom to act.
The freedom to believe is absolute. The government can never police your mind, dictate your theology, or force you to swear an oath to a specific doctrine. The inner sanctum of human conscience is totally off limits to the state.
But the freedom to act upon those beliefs, Roberts explained, cannot be absolute. Conduct remains subject to regulation for the protection of society. I mean, if your religion requires human sacrifice, the state can absolutely arrest you for murder.
Right, obviously.
The key is that when the state regulates religious conduct, it must do so using neutral, generally applicable laws that do not target religion itself and do not leave room for arbitrary bureaucratic censorship.
So if New Haven passed a noise ordinance that said no amplified phonographs on residential streets after 8:00 p.m., that would likely be constitutional.
Yes.
Because it's neutral. It applies to a teenager playing loud jazz just as much as it applies to a Jehovah's Witness playing a sermon.
Yeah.
It targets the noise, not the theology.
That is the exact line Cantwell drew. But by officially incorporating the free exercise clause against the states, the Supreme Court made the other shoe dropping inevitable.
Right.
The First Amendment has 2 religion clauses. If the states cannot prohibit the free exercise of religion, it was only a matter of time before the court declared that the states cannot establish a religion either.
And that second shoe dropped 7 years later, in 1947. But it didn't arrive via an aggressive street evangelist playing inflammatory records. It arrived in the form of a mundane, local transportation dispute in New Jersey. Let's look at the case that truly built the modern culture wars, Everson v. Board of Education.
The setting is Ewing Township, New Jersey. It's an ordinary municipality making ordinary logistical decisions. The local Board of Education, acting under the authority of a New Jersey state statute, passed a resolution to reimburse parents for the money their children spent riding regular public transit buses to get to and from school.
To be clear on the mechanics here, because I think it's important, the town is not purchasing a fleet of yellow school buses and designing specific routes.
No.
The children are getting on the regular city buses alongside commuters, paying their fare, and the town is cutting a check to the parents at the end of the month to reimburse that expense.
Correct. But crucially, this reimbursement program applied to parents of public school students and parents sending their children to Catholic parochial schools.
Enter Arch R. Everson. He is a local taxpayer in Ewing Township. He reviews the town ledger and sees his property tax dollars explicitly itemized to reimburse the transit costs of Catholic school attendees. He files a lawsuit, arguing that his tax money is being used to support and maintain religious institutions.
Everson's claim is straightforward. Taxing a citizen to facilitate attendance at a religious school is an establishment of religion which violates the First Amendment.
I really want you, the listener, to pause and put yourself in Arch Everson's shoes for a second. We all pay local taxes. Imagine opening your municipal budget report and seeing a line item where your money is directly subsidizing the operations of a religious institution that you do not belong to.
Yeah, it's a powerful feeling.
Even if you hold no ill will toward that religion,
Right.
The fundamental American instinct is to say, wait, my taxes shouldn't pay for your church.
It touches a raw nerve of civic conscience. And yet, look at it from the perspective of the Catholic families in Ewing Township. They are not grand theocratic villains trying to siphon public funds to build a cathedral.
No.
They are ordinary working-class parents. They pay the exact same property taxes Arch Everson pays. They just want their kids to have safe, affordable transportation to school, avoiding the hazards of busy roadways.
The dispute is so powerful precisely because it is so mundane. It feels like Everson is saying, I don't care if it's just a few pennies for a bus fare, the Constitution doesn't have a small change exception. It is the principle of the thing.
Exactly.
It's like arguing that if the city fills a pothole in the street directly in front of a church, making it easier for parishioners to pull into the parking lot, the city is technically subsidizing the church's mission. Where exactly do you draw the line?
That pothole analogy is exactly what the Supreme Court had to wrestle with. If an absolute total separation is required, does that mean the fire department can't put out a fire at a church because it uses taxpayer-funded water?
Right. Obviously not.
Obviously not. The state must provide general public services. So the court uses this incredibly local dispute over bus fares to finally incorporate the Establishment Clause and draw that definitive line for the entire country.
And the man assigned to draw that line was Justice Hugo Black. He is a fascinating, highly complex figure who ended up authoring the 5-4 majority opinion in Everson.
Hugo Black was a former Democratic senator from Alabama. He was a staunch New Dealer, largely self-taught in his reading of history, and he considered himself a fierce, unapologetic Jeffersonian.
Okay.
He deeply admired Thomas Jefferson's political philosophy and often looked to early American history to interpret the Constitution.
So when Justice Black sits down to write the Everson opinion, he needs to define what the phrase establishment of religion actually means. It's a vague phrase. So he goes looking for historical precedent. But he doesn't find his defining metaphor in the Constitution itself, or even in the Federalist Papers.
No, he finds it in a private letter. In 1801, the Danbury Baptist Association in Connecticut wrote a letter to the newly elected president, Thomas Jefferson. Remember, Connecticut still had an established Congregationalist church at this time.
Right, we talked about that earlier.
Yes, and the Baptists were a persecuted minority facing heavy taxes to support a church they didn't attend. So they wrote to Jefferson, a known champion of religious freedom, expressing their grievances.
Jefferson wrote back on January 1st, 1802. And in his reply, he sought to assure the Baptists that the national government stood for religious liberty. He wrote that the First Amendment had built a wall of separation between church and state.
A wall of separation between church and state. It is wild to think that this phrase, which almost every American naturally assumes is carved into the text of the First Amendment, is entirely extra-constitutional.
It really is.
It was a metaphor used by one politician in a private correspondence to a political constituency.
But Justice Black takes this metaphor from 1802, dusts it off, and elevates it into binding, authoritative Supreme Court doctrine in 1947. He uses Jefferson's letter as the definitive secret decoder ring for the Establishment Clause.
And the opinion Black produces in Everson is widely considered a masterpiece of contradiction. It is essentially two deeply conflicting movements played in the same symphony.
Let's analyze the first movement. Black starts by writing a sweeping, absolute separationist anthem. He defines the Establishment Clause in the strictest possible terms. He writes, neither a state nor the federal government can set up a church. Neither can pass laws which aid one religion, aid all religions, or prefer one religion over another.
He goes further. No tax in any amount, large or small, can be levied to support any religious activities or institutions. He explicitly quotes Jefferson's letter, declaring that the wall of separation must be kept high and impregnable.
Wow.
And he concludes this section with a definitive hammer blow. We could not approve the slightest breach.
If I am Arch Jefferson the taxpayer, and I am reading page 15 of this opinion, I am popping the champagne.
Oh, absolutely.
The Supreme Court just agreed with me entirely. The wall is high and impregnable, not the slightest breach. No tax money, large or small. I won.
But then comes the second movement, the whiplash-inducing pivot. After building this massive, impenetrable constitutional wall and insisting it cannot be breached, Justice Black concludes that the Ewing Township bus reimbursements to Catholic parents can continue.
Wait, what?
He rules that reimbursing parents for bus fares to religious schools does not breach the wall. The town won, Everson lost.
Hold on. Let's examine the methodology here, because the contradiction is staggering. First, Black uses an 1802 letter written by Thomas Jefferson, who, by the way, was in Paris serving as an ambassador when the Bill of Rights was actually debated and drafted in Congress.
Right. He wasn't even there.
Right. And Black treats this private letter as the absolute intent of the founders. And then, after establishing this absolute rule against any tax, large or small, he just waves the bus money on through. How does he justify leaving a giant permanent door open in his impregnable wall? Can judges just do that?
Well, to justify the door, Justice Black borrowed a legal framework from a decade earlier. It is a framework that shifts the constitutional focus entirely away from the religious institution and places it squarely onto the individual student. It's known as the child benefit theory.
The child benefit theory. This is the intellectual loophole that allows the money to flow.
Exactly. The precedent originated in a 1930 case called Cochran v. Louisiana. Huey Long's administration in Louisiana had initiated a program to use state funds to purchase secular textbooks, math, geography, grammar, and lend them to all students in the state, including those attending private Catholic schools.
Taxpayers challenged it, obviously, saying state money was funding religious education.
But the Supreme Court unanimously upheld the textbook program. The court's logic was that the state's interest is in the education and literacy of its citizens. The secular textbooks benefited the child's education, not the religious institution's mission.
Okay, so the Catholic school was merely the building where the child consumed a secular public benefit.
Exactly. And this child benefit theory is inextricably linked to an even more profound case from 1925, Pierce v. Society of Sisters. We have to talk about Pierce because the historical context is incredibly dark and revealing.
Let's get into it.
In the early 1920s, the state of Oregon was experiencing a massive surge of nativism, heavily driven by the Ku Klux Klan and Scottish Rite Masons. They were deeply anti-immigrant and specifically anti-Catholic.
It's important to remember how powerful those groups were in local politics back then.
They absolutely were. They campaigned for and successfully passed the Compulsory Education Act of 1922.
And this law didn't just say kids have to go to school. It mandated that all children between 8 and 16 must attend public schools. It was a deliberate, targeted attempt to completely outlaw private Catholic schools and force the homogenization of all children into the state system.
The Supreme Court struck the Oregon law down in a landmark ruling. They declared that the child is not the mere creature of the state. They guaranteed parents the fundamental constitutional liberty to direct the upbringing and education of their children, including the right to choose religious schooling.
Okay, let's synthesize this. If a parent has a fundamental right to choose a religious school under Pierce, and a child has a right to receive secular state benefits, like math books under Cochran, how does Justice Black apply this cocktail of rights to the bus fares in Everson?
Black argues that the bus fare reimbursement is a general, neutral, public welfare benefit. It is categorically no different from providing police protection, fire protection, sewage disposal, or public sidewalks. The money isn't a contribution to the Catholic Church, it is a safety measure for the child.
So the state has a secular, compelling interest in ensuring children don't get hit by cars while walking along busy highways to get to school.
Precisely. Black argued that if the state provides these neutral safety benefits to all citizens, cutting off religious families from those benefits would essentially penalize them for exercising the very religious rights guaranteed to them in the Pierce decision.
I see.
You cannot make it uniquely dangerous or financially punitive for a child to simply exist in public while exercising their faith. The First Amendment requires the state to be neutral toward religion, Black argued, but it does not require the state to be an adversary to it.
I see the logical path Black took. But we have to acknowledge how incredibly blurry and slippery this line is. If the state buys a kid a math book, it's a child benefit. If the state buys a kid a bus pass, it's a child benefit. But what if the state buys the Catholic school a brand new $10,000 smart board to teach that kid math?
Right.
I mean, the child benefits from the smart board, right? But the school also gets to keep a piece of capital equipment. Where does child benefit end and institutional aid begin? It seems incredibly blurry.
You have hit the exact logical nerve that caused 4 justices on the Supreme Court to read Hugo Black's opinion and absolutely explode in dissent.
Really?
Oh, yeah. The Everson decision was 5-4. It was as divided as the court can possibly be. 4 justices looked at Black's child benefit loophole and saw a catastrophic failure of constitutional logic.
The dissents in this case are legendary. Let's look at Justice Wiley Rutledge, who authored the primary dissent, joined by Justices Frankfurter, Jackson, and Burton.
Rutledge took a hardline, fundamentalist approach to the concept of separation. He argued that the Establishment Clause forbids any public aid that supports religion in any form, whether direct or indirect. To Rutledge, the child benefit theory was nothing more than a semantic sleight of hand designed to launder public money into religious institutions.
And to prove his point, Rutledge plays the exact same historical game as Justice Black. Black relied on Jefferson's letter. Rutledge reaches back to 1785 and appends an entire founding document to his dissent, James Madison's Memorial and Remonstrance against Religious Assessments.
Madison's memorial is one of the most important documents in American religious history. In 1784, Patrick Henry introduced a bill in the Virginia legislature that would have levied a small general tax to pay the salaries of teachers of the Christian religion. Taxpayers could actually designate which Christian denomination their money went to, but they had to pay it.
Madison wrote a brilliant, anonymous 15-point essay vehemently opposing the bill. He argued that the government has no jurisdiction over religion whatsoever, and he made a famous 3-pence argument. He said that if the government can force a citizen to contribute even 3 pence of his property to support an establishment of religion, they can force him to conform to any other establishment in all cases whatsoever.
Rutledge points directly to Madison and says, Madison fought tooth and nail against a tax of 3 pennies to support religion. Does anyone seriously believe Madison would approve of taxing the citizens of New Jersey to bus children to a school where they are taught Catholic theology?
And Rutledge also makes a devastatingly practical argument about the logistics of the buses, right? Doesn't he have a bulletproof point here? Without the bus, the kid literally cannot attend the religious school. He writes that getting to school is an essential, foundational prerequisite of the educational enterprise. If you want to go to a theme park, paying for the gas to drive there is an inherent part of the cost of the trip. The transportation is the prerequisite for the religious education. How can you separate the two? By subsidizing the transportation, you are inextricably subsidizing the religious mission it enables.
Rutledge believed Black's opinion was a total capitulation, but the most biting, memorable, and eloquent critique of Justice Black's majority opinion didn't come from Rutledge. It came from a separate, shorter dissent written by Justice Robert Jackson.
Justice Robert Jackson, the man who would go on to be the chief U.S. prosecutor of the Nuremberg trials. He was a phenomenal writer, and he did not hold back.
Jackson felt that the legal doctrine laid out in the first half of Black's opinion was entirely at war with its final judgment. He does. Jackson wrote that the majority opinion reminded him of a character from Lord Byron's poetry, a character named Julia. He wrote that Justice Black's opinion, like Byron's Julia, whispering, I will ne'er consent, consented.
Whispering, I will ne'er consent, consented. He is calling the majority of the Supreme Court hypocrites in blank verse. He's saying they talked a massive game about absolute separation, but folded the second they had to actually apply it.
It is a devastating critique. Jackson also attacked the pothole and police analogy. He argued there is a massive difference between the state providing a general public service, like a police officer walking a beat, which protects everyone indiscriminately, and the state reimbursing a specific financial expense required to attend a religious institution. To Jackson, the bus fare was an educational expense, not a public safety measure.
Because of this brutal 5-4 split and the warring logic within the majority ruling itself, Everson didn't settle the debate over church and state. It just poured concrete and gasoline at the same time.
It armed both sides for a century of culture wars. Everson is the singular case that both separationists and accommodationists confidently quote in court to this day.
When strict separationists go to court to stop public money from flowing to religious groups, they quote the first half of Everson. They cite Justice Black's sweeping rhetoric. They pound the table and say, the Supreme Court declared the wall must be high and impregnable, not the slightest breach.
And when accommodationists, those who believe the government can neutrally support religious citizens along with everyone else, go to court, they quote the second half. They cite the child benefit holding. They argue the Supreme Court said public welfare benefits can flow to religious families without violating the Constitution. You can't discriminate against us just because we are religious.
And that unresolved boundary, that blurry line between child benefit and institutional aid, directly caused decades of legal chaos in the lower courts.
Absolute chaos. Throughout the 1970s, the Supreme Court had to micromanage what states could and couldn't buy for parochial schools. The court ruled that states could lend secular textbooks, but couldn't lend maps or projectors.
Well, maps, really?
Yes. They could pay for standardized testing, but couldn't pay for field trips. The jurisprudence became a laughingstock of arbitrary distinctions because they were constantly trying to navigate the door Black left open in the wall.
So when we see headlines today about states debating whether tax dollars can go to private religious charter schools, are they basically just fighting the exact same bus fare battle from 1947 all over again?
Entirely. When we look at landmark cases like Zelman v. Simmons-Harris in 2002, which allowed public voucher money to go to religious schools in Cleveland, or the recent 2022 case, Carson v. Macon, which required Maine to include religious schools in its rural tuition assistance program. These are just the Everson bus fare fight, scaled up to billions of dollars.
Oh.
The debate over a school voucher today is fundamentally a debate over Black's framework. Is the voucher a neutral child benefit given to the parent, who then makes an independent, private choice to endorse a religious school? Or is the voucher a mechanism to launder public tax dollars into a religious institution, breaching the impregnable wall? We are still fighting on the exact same battlefield surveyed in 1947.
Before we wrap up, we need to carefully examine a major, growing movement in modern legal scholarship that looks back at Cantwell and Everson and says, the Supreme Court took a fundamentally wrong turn. This is the originalist critique of incorporation.
Yes. This view is championed by several prominent legal scholars and has been articulated forcefully by modern jurists, most notably Justice Clarence Thomas. We are analyzing this impartially as a major current in constitutional thought because it highlights the structural fragility of the Everson decision.
The originalist critique argues that the entire premise of incorporating the Establishment Clause against the states was a historical, logical, and conceptual mistake.
Remember Marshall's ruling in Barron v. Baltimore?
The Wharf case.
Right. The Bill of Rights was a restriction on the federal government. Originalists argue that the Establishment Clause, Congress shall make no law respecting an establishment of religion, was not primarily designed to create an individual right to be free from religion. It was a structural federalism provision.
It was a jurisdictional boundary marker.
Exactly. It was designed to protect the states' rights to have their own establishments or to handle religion however they saw fit, completely free from federal interference.
So the originalist argument is, how can you possibly take a constitutional clause that was specifically designed to protect state power and incorporate it through the 14th Amendment to strip the states of that exact same power?
It is a logical paradox. To use an analogy, it is like taking a lock that was specifically designed to keep the federal government out of the state's house and suddenly using that exact same lock to trap the state inside its own house.
It's a great way to put it.
Originalists argue that you can incorporate individual rights like free speech or free exercise, but you cannot incorporate a structural restriction.
Let's play this out as a thought experiment for a second. If the Supreme Court woke up tomorrow and adopted this originalist critique, declaring that Everson was wrongly decided and the Establishment Clause only restricts Congress, what happens to the country?
It would be a constitutional earthquake. Overnight, it would mean the state of Texas could legally declare a state religion. Utah could formally establish the LDS Church. A local city council in Florida could levy a specific property tax exclusively to fund the construction of a Catholic cathedral.
It's hard to even picture that.
The entire framework of modern church-state separation at the local level would vanish, returning us to the patchwork reality of 1833.
Whether you find that thought experiment terrifying or legally sound, it proves just how massive the stakes of the 1947 Everson decision truly were.
It created the modern American reality.
We have gone on an incredible journey today. We started with the founders' original, limited First Amendment, a treaty that constrained Congress but left the states free to run their own religious affairs. We saw how the bloodshed of the Civil War necessitated the 14th Amendment, providing the engine of incorporation that allowed the Supreme Court to pull fundamental liberties down to the local level.
We watched the court officially incorporate free exercise in 1940 with the Cantwell family and their phonograph on the streets of Connecticut, protecting the absolute freedom to believe while regulating the freedom to act.
And finally, we unpacked the massive defining paradox of 1947. Justice Hugo Black using Thomas Jefferson's private letter to build a high and impregnable wall, only to leave a permanent door open for Catholic school bus fares based on the child benefit theory. A decision that armed Justice Rutledge and Justice Jackson in dissent and gave us the chaotic, contested blueprint for every local school board fight over religion today.
Everson remains the sun around which all modern Establishment Clause jurisprudence orbits.
Which leaves us with a final provocative thought, something for you, the listener, to mull over long after this deep dive ends. We have spent this entire time debating this famous metaphor of a wall of separation. But think about what a wall actually is. Architecturally, a wall is inherently rigid. It is absolute. It is designed to divide the world into clean binary spaces. You are either on this side or you are on that side.
But the question is, Is a rigid binary wall the correct architectural model for a modern, highly integrated, pluralistic society?
When Thomas Jefferson wrote the Danbury Baptist in 1802, the federal government was microscopic. It delivered the mail, collected tariffs, and defended the borders. That was about it. But today, the modern administrative state touches almost every single aspect of human existence. The government is deeply involved in healthcare, in mass transportation, in zoning, in massive social service networks, and most importantly, in the education of every single child.
If the state is everywhere, providing services everywhere, and religious citizens are everywhere, participating in public life, those two spheres are inevitably going to overlap. They are going to bump into each other.
So perhaps the messy, contradictory, paradoxical door that Justice Black left open in 1947 wasn't a failure of logic. The door that made Justice Jackson mock him with poetry and Justice Rutledge append founding documents in disgust. Perhaps it was the only pragmatic choice. If the state is going to pave the roads and provide the buses, maybe a wall with a door in it is the only realistic way a diverse, pluralistic society can actually function without tearing itself apart. It forces us to constantly negotiate the boundary, case by case, voucher by voucher, bus ride by bus ride.
It forces us to continually define what it means to be both a religious person and an American citizen.
Thank you so much for joining us on this deep dive. The next time you are driving through your town and you see a yellow municipal school bus pull up to a curb to pick up a group of kids, take a closer look. Because rolling down your street isn't just a piece of transit equipment. It is a massive, contradictory, perfectly American piece of constitutional history. Keep questioning, keep learning, and we'll see you next time.